Hey, welcome to Employment Hour in 30. John Scholes and Lior Samfiru. We talk about employment rights, we talk about severance pay and everything under that banner, the place where you spend thousands of hours of your life every week. So it's important stuff to know. Didn't mean to depress you, but it's going to be a lightning show, an enlightening show for sure. Severance pay calculator, that's a cool tool. And before we get to that later on in the show in just a few minutes, you can check it out on your own, severancepaycalculator.com. To reach out, 1-855-821-5900. But we always start the show with the week that was, and this one is a contract beauty. We talked about this before.
It really is, and it falls into the category of things may not always be as they seem. And this happens, by the way, often when it comes to employment law and workplace rights. Things are not always as they seem. You may sometimes think you don't have rights when you do. You may sometimes think that there's nothing you could do about a problem when, in fact, you can. You may think that the company is doing is right when it's not. So there's a lot of misconceptions like that when it comes to your rights, workplace rights, employment law. That's what the show is all about, to demystify that, to tell you how actually things work, what the law says. So if you're ever wondering about should something be this way, don't wonder anymore. Call us, email us. We'll give you that information throughout the show. But the week that was, getting back on track in terms of something that came across my desk, as you said, it has to do with the contract. Well, let me be very specific. This particular lady I spoke with had worked in one of the major hospitals in the city for some 8 years, just over 8 years. Except every 3 months or so, John, she signed a new contract. So every 3 months she signs a contract, next 3 months another contract, and round we go. Well, I'm a lawyer, not a mathematician, so don't really know how many contracts that is. But it's a lot of contracts. Okay, that's many contracts. It's a plethora of contracts, I would say.
Nice.
But beyond that, that's all she knew. Well, very recently, when this latest contract ended, her employer, the hospital, said, we're not renewing it anymore, so you're going to be leaving us. We wish you all the best. Handshake, off you go. And she called me and she wanted to know, is that right? Well, no, it's not, and not so fast. Things are not always as they seem. She thought she was an employee on a contract. Well, she isn't. When you sign a contract that keeps getting renewed again and again and again, that contract becomes meaningless. You now become a regular, indefinite, full-time employee. Doesn't matter what you signed. Usually once you've signed a few of these contracts, they stop meaning anything. Why? Because you're not expecting to be let go anymore. You're simply expecting to continue working. Yeah, I signed a contract. Maybe after the first contract I wasn't sure, but after the second, third, fourth, fifth, 10th, yeah, I'm not expecting to be let go. So I'm a regular employee. That means now that she's going to be let go, she is owed severance, like a regular employee. And for her, it could be easily about 10 months of pay that she's owed. And I wanted to bring this up today because this is a common situation. Individuals may have signed a number of contracts and they think, well, I'm only working till the end of the contract. Well, no. If you signed a number of them consecutively, they may be meaningless. And now, if you don't have another contract, if the employer decides to let you go, they may owe you full severance. I see this, John, happening all the time.
What's the threshold as far as contracts? 2, 3, 4, dozen, half a dozen?
Usually, once you get past three or beyond, the contracts become meaningless. So the first 2 contracts, yes, legitimate. Once we get to 3, and then 4, 5, 6, etc., yeah, they're meaningless. You're a regular employee. I'm sure I'm talking to people right now that are watching us that are either in this situation now or have been in that situation where they just signed a bunch of consecutive contracts. They're meaningless. So if the company eventually decides to let you go, you're owed your full severance.
I guess it would really make sense, because if that was the case, an employer could just keep putting somebody on contract, signing and signing for 30 years, and at the end of a long career, we don't owe you anything.
Yeah, we don't owe you. So it would be very simple. Everyone would do that. I would just have people on a 1-month contract, renew, sign a piece of paper every month.
Benefits, no this, no that. Easy.
And then 30 years from now, as you've said, now I'm just not going to renew it. Forget about the 2-year severance I have to pay you. I don't have to pay you anything because you're on contract. Well, guess what? The law is smarter than that. I'm smarter than that. It doesn't work that way.
1-855-821-5900, employmenthourtv.ca. That is the website to go to find more things about this show, past shows, and our radio show as well, which has been on the go for about 7+ years now. We take phone calls, a ton of them on the show. We play them back on this show, the audio, and we comment on them. First call of the day is coming up right now.
I worked for the same company for almost 7 years. It's a father-son partners. Son didn't want me around, so I took a layoff from him, and I settled for a very cheap severance package. I took 1 week per year severance. The father wants me to continue working for him on a part-time basis. I was told I have to pay the severance back if I go back to work for the company. That's what the lady that does their bookkeeping and their accounting and stuff said.
Wow. Yeah, it's an interesting situation.
Yeah.
So here's how this works. So he's let go, and now the company says, no, we want you to come back. Okay. Well, keep in mind, he doesn't have to go back, and the company doesn't have the obligation to take him back. They don't have to. So they can say, we'll do it only if you pay us back the severance. He doesn't have to accept it, but they don't have to allow him to come back. If he agrees, they can do that. He can pay back the severance. He doesn't have to pay it back, but they don't have to take him back.
Okay.
That's simple. The real interesting issue here is much bigger than that. So he says in his call to us that after 7 years, he was laid off, took 7 weeks of pay. A week per year, the standard. Well, guess what? He is owed much, much more than that. And most people in that situation, when they get this week per year, they're owed a heck of a lot more. So the real issue is not about whether he pays it back. The real issue that he needs to pursue his full severance. He's owed much, much more money. How much? Well, let's apply that, or let's input that into the severancepaycalculator.com website and see how much he's actually owed. So you can see on the screen right now, he's been there for 7 years, a laborer. I picked an age, let's say he's 61 years old, and he was given 7 weeks' pay. Well, as you see on the screen, someone in his situation is owed 6 to 8 months of pay. Depending on what his income is, that could be $20,000, $30,000 or more. Easy. So forget about whether I'm going to pay back my 7 weeks' pay. No, you're not going to pay it back. You're going to get a lot more than that. That's why the severancepaycalculator.com website is so easy. It took us, a few seconds now to do that? It'll take you just as long to use it yourself. So the real issue is not paying it back. The real issue is how much you're owed. And by the way, John, I get oftentimes that calls when people are asking me about the wrong thing.
Right.
They're asking me about the record of employment. They're asking me about a reference letter.
How can they let me go?
When all this time they could be owed another $50,000 in severance. That's the real issue. That's why you go to severancepaycalculator.com.
Now, he could still foolishly forego that extra severance and go back to job, but...
So he can ultimately decide what he wants to do. Does he want to forgo that and go back, and they're offering him his job on different terms, part-time? Probably doesn't make sense. He can. If I'm advising him, I'm telling him, forget that. Get your full severance and move on to a different job.
Again, employmenthourtv.ca is the place to find the radio show. Call number 2 for this show is coming up right now.
I put a harassment claim in against an employee, and it was not investigated, I believe, due to the relationship they have with the top person of the company. I've recently gone to HR. They advised that I contact the Ministry of Labor, and in fact that they had not investigated it. The Ministry of Labor is now involved. But the HR manager mentioned that this could be an instant of constructive dismissal for me, as in this company I will not be able to move laterally or up.
That's a weird situation.
It is very weird. I remember that call on our radio show, and what I was thinking then is exactly what I'm thinking now is, how can the HR person for the company tell the employee, go and complain against the company with the Ministry of Labor, or you should pursue a constructive dismissal? That HR person has some explaining to do and maybe some training to get. But beyond that, here's the thing. If she's being harassed in the workplace, her employer has to, number 1, take it seriously, and number 2, investigate, and number 3, eradicate the problem, fix the problem. They can't ignore it. They can't say, well, it's my buddy, so I'm not going to investigate him. That's illegal. So right off the bat, that's a problem that the company didn't take it seriously. She's right. The fact that she can't continue working in that environment is a constructive dismissal. She's right. She doesn't have to accept it. She can leave with her severance. Unfortunately, John, the Ministry of Labor cannot help her. Okay, the only one that can help her in that situation is a lawyer. She has to get legal advice. Ministry of Labor cannot help you if you've been let go, if you've been constructively dismissed, or frankly, if you're dealing with workplace harassment. For that, you have to get legal advice. I hope she can immediately withdraw her complaint from the Ministry of Labor. Give me a call, and I'll help her.
Now, she did mention off the top it didn't get taken seriously, she suspects, because the person at the top was the one she was complaining about. What if it's the case where you have a harassment case in your workplace and the person who's harassing you is your boss and he is the top? What do you do?
If there's no one you can legitimately complain to, if you can't deal with that internally, you deal with it externally. You document what's happened. Very important always to document, and then you call me. And then we could get you out of there with compensation rather than to try to deal with the problem internally that's not going to get resolved internally. What I don't want people to do is just to continue suffering. It's not going to get better, the workplace harassment, if you don't do something about it. Don't let it impact your health. Don't go off on a disability leave. Let's talk and let's get you out of there.
You can also reach out through email anytime, help@employmentlawyer.ca. And again, 1-855-821-5900. The concept of a forced resignation. What is it? Let's talk about it. First of all, what is a real resignation, and does one get severance if they resign? We've had calls about that too.
So we absolutely have. And here's the resignation should be a simple topic. I've resigned, I leave, and with a regular resignation, you don't get severance. But here's the thing. A resignation is something that you do voluntarily and that you do unilaterally.
It's your call.
It's your call, and you're doing it for your own reasons, not because someone made you, not because someone told you you don't have a choice, not because you felt like you didn't have a choice. If you resign because you don't want to work there anymore, you have a different job, you're going to go back to school, you're going to retire, that's fine. You can do that, no severance. But you do get severance even if you resign, if the reason for the resignation is because you felt you did not have a choice. Someone boxed you in. And that's what I call an involuntary resignation. It's a forced resignation, and that's what we're talking about.
It's actually a termination.
It is.
You know, you're not resigning.
If I tell you, John, you have no choice but to resign, well, what happens at that situation is I've already decided you're not working here anymore. I've told you you're gone. The fact that you then say, okay, I'll resign, doesn't change the reality that I've terminated your employment. So a forced resignation is a termination, which means you get your severance.
Having said that, if someone comes up to you and says that, if you're viewing this show, what do they say to the person who said, you know what, you're resigning?
Well, the answer is going to be thanks, but no thanks, okay? Always. The answer should be very simple. No, I'm not resigning. If you want to let me go, you can do what you have to do, but I'm not resigning, because you don't want it to be later a situation where the company said, oh gosh, we didn't make him, he resigned voluntarily. No, if you're not resigning voluntarily, the best advice is don't resign. Simply say, no, I'm not resigning. I have no reason to resign. If the company lets you go, you get your severance. If you're going to resign anyway because you really feel uncomfortable, make sure you put that in writing. Email works beautifully. Say in that email that, well, just so you know, I'm only resigning because you told me I had to. I'm not resigning because I want to resign. Right. In that case, you can still get your severance.
People and viewers are going to wonder, you know, maybe it's the optics of the situation. You often hear say, you know, it looks better to say I've resigned rather than been let go, i.e. fired. So that's why they do it. What do you think about that?
The only time it looks better, and even then I'm not even sure about that, is if you've done something awful, something terrible, like you've stolen from the company. Well, in that case, you may want to say you've resigned. But for 99.99% of people, no, it's not better to have resigned. It's not better at all. It doesn't make any difference. In fact, it's worse, because by saying that you've resigned, you make it more difficult for yourself to get the severance that you're owed. There's no advantage. There's no record of the fact that you were let go. It's not going to hurt you down the road. If the company doesn't want you to work for them, let them make that move. Don't you make it easier on them and give up your severance. And of course, as I said, if you feel you have no choice, make sure that the company knows that, and then you can still get severance.
Quick side note: people believe that there's permanent record for all time that you were let go, right?
There really isn't. The company has to give you a document called the record of employment when they let you go. And people think, well, there's a record of something.
Right.
There isn't. That record of employment is only relevant for the purposes of applying for EI. There's no big safety deposit box where people's records of employment are kept, where your history is going to be on file or searchable on Google. That doesn't exist. So it's always better to put yourself in a situation where you get your severance rather than leave it on the table.
How does someone prove that they were forced to resign rather than voluntarily?
Easy. Put it in writing. If you're going to resign because you were forced, in your little resignation note, resignation email, say, I'm going to resign, but I'm only resigning because you told me I had to. I'm only resigning because you told me I had no choice. Don't say I'm resigning and I look forward to spending time with my family and playing golf. Don't say that. If that's not the case, say so in writing, and say so right away. Don't say that 6 months later. By the way, 6 months ago, I really wasn't resigning voluntarily. At the time that you're going to resign, if it's not voluntary, if you're resigning because of something happening and you're being put in a difficult situation, make sure that's clear in writing.
Yeah, what if it is a difficult situation at work and they're continuing to work there is very uncomfortable? How do they do it?
That's what we call a constructive dismissal. If something happens in the workplace that makes it difficult to continue working, you're mistreated, you're harassed, your job has changed, you've been demoted, and you resign as a result because it's uncomfortable to continue working, you don't want to accept that new change, that new work environment, that's a termination in the eyes of the law. You get severance. That's a constructive dismissal. There are many cases, many. I've done personally hundreds of these cases over the years where people supposedly resigned. They voluntarily walked out of the building. But in the eyes of the law, that was still a termination, and they're owed their full severance.
We'll get to the severance pay calculator in more depth. And can you refuse a performance improvement plan? We'll cover that as well. In the meantime, take a short break. The contact, 1-855-821-5900 and employmenthourtv.ca as well. Employment Hour in 30 continues. Stick around. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. Is that time of the show where we give you details on the severance pay calculator. It is more fun than Candy Crush, or some claim anyway, but maybe not. But it's very useful, and it'll benefit you much more greater and longer into life. I promise you that. Severancepaycalculator.com. Give me some details on it, though.
I think it is probably slightly more beneficial than Candy Crush, although not as addictive.
That's right.
So yeah, severancepaycalculator.com. I created that website, that tool, that app about 6 years ago to help people that have lost their job to find out instantaneously how much they're owed. I didn't want people to, when they're let go on Friday, to be worrying about it all weekend long and, oh my God, who do I call? What do I do? You simply go to severancepaycalculator.com, grab your smartphone, grab your tablet, whatever it is, and you find out in seconds. Once you're there, you're going to answer 3 simple questions: age, position, length of employment, and you're done. It's going to tell you whether what you've been offered is adequate. It's going to tell you how much you're owed. You can even calculate that in dollars if you wanted to. It's simple, it's anonymous, it's free, it takes seconds to use it, and it's the very first place you go to. In one hand, you have your severance letter. In the other hand, you grab your phone, you input that information, and now you know. You're comparing your severance letter to what the calculator says. If it's adequate, you're feeling good about it. If it's not, you call me. You can do that directly if you want from the calculator. There's a green button. You press it to contact me. The first place you go to, even if you haven't lost your job, even if you're just worried about losing your job or are curious, simply you go to severancepaycalculator.com.
You know, all kidding aside, too, it's brilliant that you came up with this, because until this point, it was like, oh, you had to call a lawyer. Forget it. I'm not going to bother. Whoa.
Yeah.
You lose thousands of dollars.
Well, absolutely. But most people didn't realize that they have that much at stake. Well, even if a lawyer can help me get another week's pay, what's the point? Well, no, it's not a week's pay. It could be another 8 months' pay. That's why you don't have to take my word for it. Simply go to severancepaycalculator.com. And when you know how much you're owed, at least then you can make an informed decision.
We'll break it out, get to an example. Right here, 47-year-old Ray worked in a technical role at a small company for 9 years. His work was constantly praised by his superiors, but that changed when a new manager joined the team, as it often does. Ray's performance was questioned, and he was let go for cause within a matter of weeks. No severance pay. Is he entitled to anything?
And by the way, this is a real situation. We changed Ray's name to protect the innocent, so to speak, but the reality is you don't become a bad employee after 9 years just overnight. You don't go 9 years as a good employee, good performance reviews, and then somehow you become this terrible employee that can be let go for cause. Clearly, this is a situation, and I've seen it happen many times. We've discussed this before on the show, where you get a new manager and you just don't click with that manager, and that manager maybe doesn't like you, or you don't see things eye to eye. Well, if that happens, John, that's okay. The company can still let you go, but they have to pay full severance. For Ray to be let go for cause without severance, he would have had to do something awful after 9 years, and there's no way that happened. So Ray has been wrongfully dismissed. Ray is owed severance. So we've been talking about the severancepaycalculator.com website. Let's see how much Ray is actually owed. He's not been paid anything. So you see on the screen here from severancepaycalculator.com, Ray is in a technical role, 9 years of service. He's 47 years old. I picked the salary. Let's say he makes $72,000. And of course, he wasn't given any severance because the company says cause which is nonsense. Well, Ray correctly is assessed as being owed 9 to 12 months pay, assuming a salary of $72,000. That's somewhere north of $55,000. It could be as much as $70,000 difference that he is owed. And by the way, this is a real situation. We didn't make it up. We didn't think of something outrageous. This is something that came across my desk very recently. We just changed the name. That's how easy it is. That's how it works, and that's what you have to use it. For Ray, that meant as much as $70,000.
From 0 to 12 months just for using the calculator. It's insane.
And as quickly as I spoke about it, that's how quickly it is to actually use it. You don't believe me? Check it out.
EmploymentHourTV.ca. Again, that's the place you go to find out where you can catch our long-running radio show, where we get a ton of phone calls, and we take them, play them back on this show, and we talk about them. Another call for the morning is coming right now.
Basically, I was laid off by an employer. I never pursued it. It was actually about 4 to 5 years ago. Is it something that I could still pursue now, or is there a time period?
I hate this call.
So probably the most common question that I get is, I've been let go, what do I do about it? Second most common question is, I've been let go a bunch of years ago, what can I do now? So exactly like this call we just played, where someone has been let go, in this case, some 4+ years ago, they just now realize, well, wait a second, I had entitlements, I didn't pursue them, can I still do it? The answer is unfortunately no, you cannot. There is a 2-year limitation period, and I want to stress this, that it's a strict 2 years. It's not kind of 2 years.
Ballpark.
It's not a ballpark.
It's
not
2 years.
2 years and a couple of days. It's 2 years. So anything beyond that, unfortunately, you give up your rights. And I've personally spoken with hundreds of people that in the 15 years, 16 years that I've been practicing law have walked away from entitlements that they didn't know. And by the time they realize they owed something, it's too late. So please, please don't let that happen to you. This particular call, we had to give the same bad news. No, you're out of time. You can't do anything about it. If you've been let go, don't wait 2 years. You can, and you're able to do that. Not a good idea,
right,
because you need that income, you need that severance, you need that to live, to pay your bills, to carry you until you find another job. So contact me right away. Go to severancepaycalculator.com. But once you're beyond that 2 years, unfortunately, you've given up your rights.
I remember when we started the radio show almost 70. Remember we had that call? The guy was like maybe early 70s when he got let out. Am I out of time?
Yes,
just a little.
Slightly. Yeah, I remember in the 70s,
years.
and he said, well, did it matter that I forgot about it? No, unfortunately. So that was an extreme case.
Right.
But even more common is for me to get calls from people who have been let go 2.5 years, 3, 4, 5 years ago.
Yeah.
Unfortunately, in all those situations, if it's been more than 2 years, you are out of time.
The performance improvement plan, can you refuse it? We'll tackle that when we come back, and another phone call as well. Lots more of Employment Hour 30 is on the way. Stick around. That guy was great.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru, tackling your workplace rights here and on the phone calls as well. EmploymentHourTV.ca is where you find a radio show where you can catch our show for the past 6+ years. Another call from the show right now.
I have a friend who's been a bank employee for around 25 years. She's in her early 50s. The situation is that the bank eliminated her position. It was a customer service role in essence. Now they basically have her coming in and just doing whatever is required day to day, and she's getting instructions by the day. So I just want to know, how long could she go with going along with whatever they say, and she just doing random day-to-day activities? How long does she have to treat it as a constructive dismissal?
Clock's ticking,
Yeah,
literally.
Yeah.
So here's how this looks like. In this case, he said it was a bank. So she works for a bank, and banks eliminates the position. Rather than doing, I would say, the right thing is just letting her go, pay her severance, let her just move on. They say, no, we're not letting you go. We'll just find some odds and ends for you to do.
Keep you busy.
Yeah, keep you busy so that you're not just sitting there. So instead of having a regular job, she's doing little tasks here and there. Well, obviously, the terms of her employment have changed. She's no longer doing her job. Her job has been eliminated. So she can treat that as a termination, a constructive dismissal. Our regular viewers know this. If your job changes, you don't have to accept it. You don't have to keep going into work. You can treat that as a termination and force the issue. Now, if she's been doing this for a while, this is where the question comes in. She's been doing this now for a while. When is it too late?
Yeah.
When is she now stuck in this new reality? Well, it does depend. Depending on how much they've changed and how they changed it, usually I say it's a few weeks. You only have a few weeks to pursue a constructive dismissal. If it's been more than, let's say, 3-4 weeks where you're now doing this new job, this new tasks that they've given you, you're considered to have accepted it. And then you can't pursue this as a constructive dismissal. So you have a very short window. And I hope that in this case, it's not too late. I hope in this case, she didn't spend too much time in this new role. But it's very important for everyone watching us right now. If your job changes, your pay gets reduced, you get demoted, you get relocated, whatever it is, you only can try that out usually for a short period of time. Anything beyond that, it becomes your new term of employment, and then you're stuck.
And it could get worse because now they can do it again once you've deemed to accept it, correct?
So they changed her job. They didn't have a right to, but she let them do it. Well, the next time they do it, now they're going to change it again. Now it's going to be even worse. At that point, she's stuck. She can't do anything about it because she let them do it that first time. And the same thing applies to whether they change your compensation. You took a pay cut because you wanted to take one for the team. You wanted to be a good team player. Well, by taking that pay cut, you've given the company the right to do it again. And that's a problem. Who wants their pay to be impacted that way? So don't let that happen to you. Don't let the terms of your employment change.
If you have questions, another resource for you is terminationquestions.com. You can put your question there and we either answer it on the show or outside of show hours. It will get answered by Lior or a member of his team. One right here says, I was put on a performance review plan. I disagree with it, but they said they would fire me if I didn't accept. The process was biased and I became so stressed that I had to take a 3-month anxiety leave. I'm returning soon, but they will put me back on the plan. What do I do?
Well, it's okay to acknowledge that you've received the plan, that you physically have been given the plan.
I got it.
That I got it. I have it in my hands. But if you don't agree with what it says, you can't accept it. You can't. Not only can you not accept it, you have to put in writing why you don't accept it, why it's not accurate, why it's biased, why it wasn't properly done and what it didn't take into consideration. You have to put your position in writing because if you just accept it, then by doing that, you've essentially acknowledging you've done something wrong, even though you don't feel like you have. And down the road, when the company wants to let you go for cause, they'll say, well, we can't let you go for cause. You've acknowledged you did something wrong back then. Right. Well, no, you don't want to do that. Don't make it easier for the company to let you go for cause. If you've been put on a performance improvement plan, you don't agree with it, or given a negative review or a warning or a disciplinary letter, if you don't agree with it, say so in writing. Don't just accept it. Make it more difficult for the company to consider letting you go for cause. And of course, I'm not suggesting you do that aggressively, disrespectfully. Simply a very nice written email. I'll help you draft it if you want me to, saying, here's what you didn't know, or here's what actually happened, and I want you to know this, employer. By doing that, you're going to make it more difficult to be terminated for cause.
I think this speaks to another reason why it's so important with this situation and any others during your working career. You have to document stuff, emails, paper file, keep it going.
That's why I say you do it in writing, because if you do it in writing, then they can't deny that you've done it. They can't say that you never said it. They can't become a he said, she said. Put it in writing. Make sure that they know, because if they're going to give you the performance improvement plan in writing, they're not going to tell you about it verbally. So you have to respond in kind, and if you do that, you're protecting your own rights.
Severance pay calculator one more time.
If you lost your job, you want to know how much you're owed, you're a friend who lost your job, you're worried about losing your job, you're wondering what may happen, severancepaycalculator.com. It takes seconds to use, free, anonymous, no excuse not to use it right now.
Hope you enjoyed the show. Thank you for hanging out. You want to contact Lior now that we're done, 1-855-821-5900, employmenthourtv.ca. You can also email, that is help@employmentlawyer.ca as well. Till next time, Employment Hour 30. We'll see you next week.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.